Well, Steve, glad you could join us on the program tonight. Thanks for your time, sir.
My pleasure as always, Cam.
I was inundated yesterday with folks sending me links to news stories about Justice Stephen Breyer's appearance on Fox News Sunday, where he discussed the Second Amendment and his belief that the Founding Fathers would have agreed with virtually every restriction on firearms that this country has come up with, including the outright bans on handguns in Washington, D.C. and Chicago, because in his words, I guess, the Founding Fathers weren't really that concerned about the right to own a gun. They were more worried about ratifying the Constitution, and that's why they just threw the Second Amendment in the Bill of Rights. What's your take on this?
Well, Justice Breyer has made a discovery that no one else anywhere in the world knows about. The founders wanted gun control. It's like there's no surviving document from the 18th century that even implies that. It's like, where does this come from? It's really humorous. He made this statement, and I'm quoting him. Madison was worried about opponents who would think Congress would call up state militias and nationalize them. This can't happen, said Madison, said Breyer. Now, my book, The Founders' Second Amendment, covers everything that Madison said about the Second Amendment and every pertinent thing he said about the Bill of Rights. Madison never said anything about the state militias or about nationalizing them by the federal government. The only thing that Madison said, in addition, of course, to drafting the Second Amendment, was there's a handwritten outline of a speech that he gave when he introduced the Bill of Rights to Congress in June of 1789. And he mentioned the fact that the English Bill of Rights was deficient because arms were guaranteed only to Protestants. So he was concerned that our Bill of Rights be more extensive, and of course he gave us the language that we have in the Second Amendment, but he didn't say anything about the militias in that speech. The Second Amendment has a well-regulated militia clause, but he didn't mention anything about it, much less did he say, and I'm quoting Justice Breyer, that can't happen.
Well, yeah, and there's, I mean, as I watched the clip of Justice Breyer yesterday, what kind of struck me, and I realize this is television, you speak in sound bites, but Steve, it was just so far removed from history. That's what was troubling to me is, I mean, when you go and you look at even in the Federalist Papers when Madison wrote, quote, besides the advantage of being armed, which the Americans possess over the people of almost every other nation, the existence of subordinate governments to which the people are attached and by which the militia officers are appointed forms a barrier against the enterprises of ambition, notwithstanding the military establishments in the several kingdoms of Europe, which are carried as far as the public resources will bear, the governments are afraid to trust the people with arms. Hey,
something Madison actually said.
Yeah. You know, this turns history on its head. The Founding Fathers were not afraid to trust the people with arms. It was the people with arms who had secured the freedom of the new nation.
You know, he says founders wanted gun control. Would you name me one gun control law that they actually passed or even discussed passing? No. There's only two things to mention. One is, if you were of militia age and were a white male citizen, you had to possess a gun.
Mm-hmm.
Banning guns, they made you possess it. Number two, in the southern states, there were the slave codes. And that was the only real gun control comparable to today's gun control, where guns were actually banned to African Americans. But other than that, the founders couldn't conceive of banning handguns in a city? And let me give you a little legal advice here. Don't take Justice Breyer's legal advice to heart. He said that anybody who really wants to have a gun, he tells them, go to Maryland. You like to shoot pistols at targets? You can get a gun in Maryland. I tell you what, if you're a D.C. resident, you go get a gun in Maryland, that's a federal felony. Hello, the Gun Control Act, 1968, makes it a felony to acquire a gun and a handgun in another state.
So Justice Breyer swung for the fences, but kind of struck out, it seems, yesterday, Steve.
Well, I don't think he's going to get the annual Barcroft Historical Award or whatever. What was the one that?
The Bancroft Prize, the Saul Belle-Isle or Michael Belle-Isle Award.
Maybe he would be a good candidate after all for that.
We laugh about this, but at the same time, Steve, this is a Supreme Court justice. I mean, this is somebody who frankly, I think should know more history than I do. I was a little. I have a hard time describing my reaction upon seeing this yesterday. I was actually, I guess, a little disappointed in Justice Breyer that his history and his facts were just so off when it comes to the Second Amendment.
But it relates to the other part of his presentation. What is his approach to interpretation of the Constitution?
Mm-hmm.
Pragmatism, he says. Flexibility in the face of ever-changing circumstances. Those are code words for don't follow the text of the Constitution, don't follow its original meaning. It has no objective meaning. It's up to judges to decipher the values in the Constitution and to decide for themselves these questions. And how much further can you get these so-called values when the Second Amendment explicitly says the right of the people to keep and bear arms shall not be infringed? What kind of value is left when you say it's okay to ban handguns or conceivably ban all guns? Because under his approach, nobody has any right to keep and bear arms.
Well, that's the thing. I guess, under this pragmatic view of the Constitution, if a judge just happens to think that a right is old-fashioned and doesn't really apply or exist anymore, then I guess by Justice Breyer's philosophy, they could just go ahead and apply whiteout to the Bill of Rights and take away the freedoms that they don't like?
Right, and this is what the framers intended, he said. There was a joke they told us in the first year of law school. If you go to an economist and you ask what is 2 plus 2, he says 4, and you go to some other people, they have an answer, and then you go to a lawyer, and he pulls down the shades and whispers in your ear, how much do you want it to be? I mean, this is that same kind of philosophy. 2 plus 2 is anything you want it to be. And that's what we get with this judicial pragmatism, the idea that judges are omniscient. They can discern the framers' intent, things the framers never said, the opposite of what they expressed in the Constitution.
Yeah, and help me out with something, Steve, because as Justice Breyer talked about the judicial philosophy that he has of having to have this flexibility that to adapt to ever-changing circumstances, our Constitution actually provides for that flexibility. It's called the amendment process. What in this sort of quote unquote pragmatic viewpoint or the living Constitution a school of thought, what purpose did the founders have for providing means for us to amend the Constitution if we're supposed to just leave it up to the judges now?
Well, we really don't need to amend the Constitution when we've got judges who can do it. I mean,
so they just kind of blow right by the idea that we can amend the Constitution if we want to change it.
Well, the thing is, this is lawlessness. You either have the rule of law, you have to go by set rules, and you have to change them by set procedures, or if you have people in positions of power who can basically impose their own arbitrary value judgments, that's no longer called the rule of law. And to appoint people for life into a position where they can do that, I mean, we only won the Heller case by 5-4. We have another judge there, Justice Sotomayor, who promised to recognize the legitimacy of the Heller decision and promptly voted in McDonald not to do so. I mean, that decision questioned the presidential effect of Heller, that it was wrongly decided.
Mm-hmm.
We're in a difficult situation, a dangerous situation. If we lose one of our 5 and there's another one put in place that will be appointed by persons who don't believe in the Second Amendment, then we could end up with quite a shipwreck.
Yes, indeed we could, which is one of the reasons why I'm glad that you're fighting in the courtrooms for us. We got a lot of folks around the country who are standing up and doing what they can to strengthen and support the Second Amendment. Because you're right, at the Supreme Court, the razor-thin margin could go the other way if God forbid, President Obama gets to or nominate a replacement for one of the 5 justices who voted to uphold the Second Amendment in Heller and McDonald. And in the meantime, Steve, you're still fighting for the chance to actually exercise your Second Amendment rights in Washington, D.C. with the Heller 2 case, right?
That's right. It's pending before the U.S. Court of Appeals for the D.C. Circuit. The district basically claims it can do anything it wants to do, despite what the Second Amendment says as verified by the Supreme Court. And there, and with Mayor Daley in Chicago, the whole idea was, we lost our cases in the Supreme Court, then we'll make life a living hell for gun owners. And that's exactly what these provisions do. Everywhere you turn, they're coming at you with another regulation, another restriction, an expiration of your registration. That's anything but what the framers intended when they adopted the Second Amendment.
Yeah. Well, Steve, again, I'm really glad you could join us on the program today, and thanks again for your time, sir. Look forward to doing this again very soon.
Well, let me say to the readers, if you want to know what Madison said, my book, The Founder's Second Amendment, gives you every pertinent quote from Madison, and I'd like to see the footnote here where Madison said that can't happen in relation to this militia argument.
Maybe Justice Breyer could get a copy for Christmas.
That's right. Somebody should send him one.
All right, Steve. Thanks so much, sir. Look forward to talking again soon.